Good morning, everyone, and welcome to our POPIA in the Workplace webinar. We do have a number of guests joining us today, so we'll give them a few moments to sign in and get comfortable. In the meantime, there is just a few housekeeping issues we want to run through to make your experience more valuable on this webinar. As participants, you are automatically placed on mute and your chat function will be disabled. However, you can use the Q&A function at the bottom of your screen to submit any questions you have to us. We will try and address all of your questions during this webinar, but unfortunately we'll not be providing written responses to your questions. We are recording the webinar, so a copy of it will be uploaded on our website later for you to watch. So for those of you who have just joined, good morning and welcome. Today we'll be discussing the provisions of the Protection of Personal Information Act, commonly referred to as POPIA, with a particular focus of its impact in the workplace. For those of you who don't know me, I am Nadine. I'm currently a senior associate at Bowmans, specializing in employment and data protection. I'm joined by a partner, Talita Laubscher, in our employment department. Talita took a keen interest in POPIA when it was first drafted as far back as 2013 and has been advising clients ever since on the Act. We also have a very special guest with us today, Russell Null. Russell, thank you. Russell is the Data Protection Officer of Alexander Forbes, and he is an experienced privacy practitioner. He has several international recognized certifications and actually was the first certified senior lead privacy implementer in South Africa. So thank you very much for joining us, Russell. We're delighted.
You're welcome. Thanks for having me.
So for purposes of today's webinar, we would like to give you a high-level overview of the most notable provisions of POPIA as they apply to employers. And we'll also then engage on specific queries that we have received relating to the employment sphere and POPIA. Hopefully during this time address most of your questions. So it was just last week that we saw South Africa's largest data breach hit the headlines. Experian accidentally shared the personal details of 24 million South Africans and nearly 800,000 businesses with a fraudster in May, and was able to obtain the data now in August via a court order. And South Africa is a haven for cyber criminals. We've actually been found to have the highest probability of suffering a data breach. So it is against this background that many South Africans welcomed the implementation of the majority of the provisions of POPIA on 1st of July this year. And POPIA will apply to the processing of personal information by both private and public bodies. Personal information is any information relating to an identifiable living natural person, or where applicable, a juristic person. And the term processing encompasses a wide variety of operations and activities. It includes as collection, transferring, using personal information, and even retaining personal information. So the Act will have far-reaching implications for employers that use employees' personal information, such as their identity numbers, employment history, and references, and the like. And a failure to comply with POPIA can have significant consequences. This includes hefty administrative fines of up to 10 million rand or even imprisonment in certain circumstances. And this would be in addition to any reputational damage suffered. But having said this, we do have a grace period of 12 months, which means that employers need to ensure that they get their data privacy affairs in order by 1st of July 2021. But both our president and the information regulator have, of course, encouraged compliance now and for employers to take steps to ensure that they are already complying with the Act. So one of the notable provisions of POPIA is that it regulates how personal information may be processed, and it requires employers to process personal information lawfully. Talita, what does this mean? What must employers do when they're processing personal information going forward?
Thanks, Nadine, and good morning, everyone. It is good to join you on this very interesting topic. First, I just wanted to comment on the definition of personal information. It is really very widely defined, and it includes anything that attaches to a person, or as Nadine said, where applicable, a juristic person like a company or a trust or whatever other juristic person there might be. Now, when you look at that definition, it includes things like your race, sex, gender, pregnancy, marital status, those things. Also, information relating to the education of the individual or the medical, financial, criminal, or employment history of the person, any identifying number, an email address, a telephone number, an ID number, of course, the biometric information of a person, like your fingerprints and your retina information on your eyes. And then, very interesting, the personal opinions, views, or preferences of that person, and the views or opinions of another individual about that person. Now, does this mean that I can walk up to Nadine and say, Nadine, what you think of me is my personal information. You better share what you think of me. No, thankfully, the Act doesn't go that far. The Act regulates personal information contained in a record. So when we are talking about the employment sphere, it would be things like performance appraisals, employee files, your sick notes, anything that goes into your employee file, and it is contained in a record. So insofar as those things are concerned, the Act would apply. Not the manager's opinion of me, that's not anywhere in a record. And it is important also to look at what's a record, because that too is very widely defined. In fact, this webinar is being recorded. So this is a record of personal information. You can see from this webinar that I'm a white person, I have green eyes, I have very mousy hair, and that information is now in a record. So it means any recorded information, regardless of form or medium, including writing on any material, information produced, recorded, or stored by means of a tape recorder, computer equipment, any label, a marking, or other writing that identifies or describes anything, a book, a map, a plan, a graph, or a drawing, a photograph, film, a negative, a tape, or any other device in which visual images are embodied. And that record needs to be in the possession or under the control of the responsible party, which in this case would be the employer. And it doesn't matter that it is created by the responsible party or not, but if it is in its possession, the responsible party is the one responsible, and regardless of when it came into existence. So if you have historic documents or records in your organization, the Act will apply. So it's not only records that are created from the 1st of July, 2020. So with that background in mind, the Act basically stands on 8 pillars. And we call these pillars the conditions for lawful processing. The first one is accountability. The responsible party is that it is responsible and it is accountable for what happens with the personal information of data subjects in its possession and under its control. The buck stops there. So if you are the responsible party, it means that you determine the purpose for the processing, and that is then the party that is going to be held liable for how that information is treated. So that is the first pillar. The responsible party is responsible and accountable. The second one is the processing limitation. Now, there is a widely held misconception that you can only process personal information with the consent of the data subject. And that is not so. Our common law recognizes that the right to privacy can be limited in, broadly speaking, 2 circumstances. And that is with consent, of course, but also where necessity dictates. And this condition, number 2, our second pillar, embodies that principle from the common law. And it says that information can be processed if it is by consent from the data subject, or where it is necessary in a number of circumstances. So where it is necessary to fulfill the terms of the contract, for example, or where it is necessary for the responsible party to comply with an obligation imposed by law, or where it is necessary for pursuing the legitimate interests of the responsible party or a third party to whom the information must be provided. Also, it means that the information must be processed lawfully and in a reasonable manner. So here we have the proportionality principle. It must be reasonable. You look at the purpose and you look at the means, and the means mustn't be more excessive to achieving the purpose for which it is processed. And also the minimality principle. It says personal information may only be processed if the purpose is adequate, relevant, and not excessive. So that is in our second pillar, processing limitation. Also under that principle is that we should, where possible, collect our information from the person to whom that information relates. So we should, where possible, collect it directly from the data subject. But of course, there are circumstances in which that would defeat the whole purpose. So the Act recognizes that it isn't necessary to collect the information directly from the data subject where it might prejudice a lawful purpose, or where the data subject, it would be in the data subject's legitimate interests to process to obtain the information from another source. So moving to the third pillar is the purpose. We've spoken a lot about the purpose, and the purpose must be lawful, specific, explicitly defined. So we cannot just simply say, we are processing your personal information for our purposes. No, we need to be explicit about why we need to process personal information. And for example, in employment contracts, you would explain that this is for purposes of talent management, for purposes of ensuring that benefits are paid, benefit contributions are paid, for purposes of performance management. You would actually go and put out those principles and purposes so that they are explicit and that they are specific. Then when it comes to the retention of the records, you shouldn't retain these records for longer than what is reasonable and reasonably necessary in order to achieve the purpose. And there you would often look at other pieces of legislation that might prescribe the required time period for which you need to keep records. There are various pieces of legislation that deals with this. For example, the Basic Conditions of Employment Act, LRA, the Occupational Health and Safety Act, and you would make sure that you comply with those principles. Something like, for example, information collected by an applicant in a recruitment scenario. Now, applicants have the right not to be unfairly discriminated against, and they could potentially make a claim for unfair discrimination if they are not successful. And in order to enable you to defend such a claim, you would need the information relating to the successful candidates, but also the other candidates that were not successful. And those claims need to be instituted within 6 months of the date of alleged discrimination. But remember, the non-compliance with that time period can be condoned. So it's advisable to keep those kinds of records for a longer period, say, for example, 12 to 18 months. So that is also something that would be important. You would look at the type of information that you are collecting. You would look at the purpose of collecting the information, and you would look at what is the time period for which I need to retain this information under the law, or for example, in this case of employment equity, under, the enabling us to defend that might be instituted against us. And once that time period has lapsed, the responsible party has the obligation to destroy or delete the record, but it can also de-identify the information as long as it isn't in a manner that can be easily re-identify the data subjects to whom it relates. Then further processing. So now I have all this information. Can I now do direct marketing? Can I sell this information? No, you can only process it further if that purpose, that further processing purpose, is compatible with the initial purpose. Otherwise, you will need to go through the whole exercise again. Number 5, and yeah, I'm moving fast because we have a lot of ground to cover. The 5th pillar, information quality. So the reasonable party, the employer, must take reasonable steps to make sure that the information it holds about its data subjects is accurate. And for that reason, we often include in our employment contracts a clause to put an obligation on the employee to inform the employer if any of the information changes. Russell is moving house. He will need to change his address in their records. Nearly 20 years ago, I got married. I needed to tell my employer, now my status changed. I'm now no longer single. I'm married. So it is an obligation that is placed on the employee, but it enables the employer to make sure that the information is accurate. Ultimately, it's the responsible party that needs to make sure that it has accurate information in its possession. Then the 6th pillar, openness. This means that we must tell the data subjects what we're doing. We must notify them at the time of processing what information is it, the purpose for which it is collected, the name and address of the employer, the consequences of the failure to provide it, what is the level of protection if we are going to send this information to a third party in another country, and any other information that's relevant, the likely recipients of the information, also the right for them to ask whether we hold certain information about them, and the right to object in certain circumstances to the processing. So that is the openness requirement. Number 7, the security safeguards. That's important. The employer is the responsible party. It needs to be sure that there isn't going to be a risk, or well, that there will probably always be a risk, but that it mitigates the risks of unauthorized access to information, and it needs to do that by way of technical and organizational measures. Then also, if you have a third party, an operator processing information on your behalf, there needs to be a written contract in place in terms of which that operator is then obliged to ensure the confidentiality and the security of the information. And then lastly, data subject participation. So it's not just about openness, but it is also about participation. A data subject has the right to ask the responsible party whether it holds certain information about her or him. And it can also ask for the record itself or a description of the information held by the responsible party. And then the data subject furthermore has the right to request the correction or the deletion of information. And upon that request, you cannot just dismiss it out of hand. You have to consider that. And if there's validity in the request, you need to correct the information or destroy or delete it, whatever the request is. Or if you do not agree that that information ought to be deleted, then you need to affix a copy or a note of that request to change or delete the information to that specific information. So that was a mouthful. That relates to normal personal information, as we spoke about the definition. there's additional protection granted to a special category of information. And generally speaking, that type of information mustn't be processed without consent. There are very limited circumstances in which that kind of information, the special personal information, can be processed without consent. And I'm just going to list these types of information in the interest of time. So that includes your religious or philosophical beliefs, race or ethnic origin, trade union membership, political persuasion, health or sex life, or biometric information, as well as the criminal behavior of the data subject.
Thanks so much, T. I think in addition to the processing of personal information in accordance with those 8 conditions, and the special protections for your special category of information, POPIA also seeks to regulate your transfer of personal information to foreign countries. And this is particularly important to multinational organizations that might have group companies in other countries where they transfer personal information to the group companies as part of their business operations. Now, POPIA contains a general prohibition to the transfer of personal information cross borders. There is, however, certain exceptions to this prohibition. The first exception includes where you transfer personal information to a third party in a foreign country that is subject to a law or binding corporate rules or a binding agreement that provides an adequate level of protection that effectively upholds the principles set out in POPIA and has similar provisions to the processing of personal information as set out in POPIA. So you can then process information with a country that has sufficient laws, or with a third party in a country such as India that doesn't have sufficient laws, but you enter into a data transfer agreement regulating what they can do with that personal information and actually incorporating a number of the provisions of POPIA into that agreement. Now, unfortunately, POPIA doesn't provide us yet with much guidance as to which countries will be regarded as having adequate protection, or the manner in which employers are supposed to go about identifying which countries are sufficient. POPIA was drafted on the basis of the Data Protection Act in Europe. However, Europe has since moved ahead and adopted a new General Data Protection Regulation, commonly referred to as the GDPR. So whilst our legislation was drafted on their old legislation, it does appear that, the GDPR will be regarded as giving adequate protection, and that we will be able to sort of transfer information to Europe because they're subject to adequate laws. But we will hopefully get more guidance from the information regulator in this regard. In addition to this sort of safe harbor exemption, there are other grounds on which you can transfer personal information across borders. This includes where the employee or data subject consents to the transfer, where it is necessary for the performance of a contract, which the data subject is a party, or where it's actually in the interest of the data subject and it just is not reasonably practicable to obtain their consent. So there are additional grounds on which you can rely on to transfer the information. The most cautious approach would obviously be to ensure that the third party receiving the information is subject to adequate laws or provisions by way of an agreement or binding corporate rules. We just want to point out in this regard, if you are intending to transfer special personal information to third parties in a foreign country that does not provide adequate protection, there is a requirement under POPIA which requires you to get the information regulator's prior authorization to that transfer. So before you can transfer the special personal information to a country with not adequate laws, you do need the prior authorization. There is some other circumstances in which you may require prior authorization from the information regulator. This includes where you're processing information relating to criminal behavior, or where you're processing personal information for purposes of credit reporting. So just to bear in mind that there may be occasions where you do need the consent of the information regulator to transfer personal information. One of the other notable provisions of POPIA, which a lot of companies are sort of taking interest in, is the requirement to register an information officer with the information regulator. Now, the information officer is by default the head of a private body, unless otherwise appointed. And in terms of POPIA, the information officer is responsible to ensure that the employer organization complies with the 8 conditions for lawful processing, as just discussed by Talita, also to assist with requests made under POPIA, and to assist the information regulator with any investigations that may be conducted. The regulations under POPIA actually set out additional duties for information officers. And that came out, 3 years after this, the draft of the Act. And the additional duties include information officers requiring to develop and implement a compliance framework, actually conducting personal information impact assessments, drafting a POPIA manual, and conducting awareness sessions on POPIA. And we just wanted to alert you to the fact that the information regulator has just recently published guidelines for the registration of information officers. And what has been confirmed in these guidelines is that the information officer for POPIA is the information officer in terms of your promotion of access to information act. So they're one and the same person. So when you appoint an information officer, they must ensure that they comply with their duties in terms of both POPIA and your promotion of access to information act. There is now a form that's been attached to the draft guidelines for purposes of registering your information officer. And the guidelines actually require you to submit that form before 31st of March next year. That's currently as it is drafted. One additional point to note is that POPIA does allow you to appoint deputy information officers. So this can be a great thing in large organizations where you have a number of processes in place. You can delegate different responsibilities to various people to ensure compliance with POPIA. Now, the guideline actually states you must appoint deputy information officers, which is not exactly in accordance with the Act. And it does say you must provide these deputy information officers with the necessary resources and financial means in order to ensure that they can monitor compliance with POPIA. These are, of course, still draft guidelines. We'll wait to see, in terms of comments that were submitted, whether they will be changed before finalized. But I think the 31st of March is a date to just bear in mind at the moment. And lastly, in terms of the last provision we want to bring to attention is this new requirement to report data breaches. We briefly mentioned Experian earlier, and whilst a number of data breaches actually flew under the radar, POPIA now requires an employer or responsible party, when there are reasonable grounds to believe that personal information has been accessed or acquired by an unauthorized person, they must, in writing, notify the information regulator and the data subjects concerned. And this notification must be made as soon as reasonably possible when the actual breach came to the attention of the employer. But Russell will provide us with more detail on data breaches later on in the webinar. I think, firstly, Russell, would you like to just share with us some of the challenges that you have faced as an information officer and how you have gone about best dealing with these challenges?
Sure, thanks, Nadine. First, I should just say that I can talk about this for days, so I've been given strict instruction to try and keep it short. I have 3 key things that I've been thinking about, not only as during my time at Alexander Forbes as the data protection officer, but also as a consultant in the information security and data protection space over the last decade. And one of the key things, especially from an employee perspective, is that this is new for most organizations. Like POPIA and the idea of data protection is new. You used to have your information security guys tucked away in a corner somewhere, and those are the people that were supposed to look after data. But this really has a far-reaching impact across your entire organization. And so POPIA and other data protection laws are forcing us to consider our data and our personal information in more detail than we've ever considered before. Talita spoke about purpose. So you need to know why you are collecting that data. When you start looking at security safeguards, you need to know where it is stored, who has access to it, how it's protected. These are not things that people tend to think of in their day-to-day business or in their day-to-day operations. And so consequently, most people actually don't know what to do. It's all good and well to come at this with a compliance approach and say, well, you need to comply with the law. And this has been one of the challenges that I've seen with some of my clients. Compliance usually takes the lead. Now, I am not a compliance practitioner. I am not a lawyer. I have a technical background. I have a Bachelor of Science in IT. So I understand systems. I understand data. Well, at least I like to think I do. And the important thing for me, for most employers, is that training is key. Educate yourself as to what the requirements are and educate your people. Empower your entire workforce, because this is not just something that you can leave to a data protection officer. Alexander Forbes is an organization of 3,000 people strong, plus contractors, plus external parties and external service providers. There is no way that a single person or even an army of deputy data protection officers or information officers can get this right all on their own. The other thing is that this skill set, information security, is a scarce skill set, and data protection or data privacy or privacy laws is equally as scarce. So the legal firms will tell you what you need to do, but often they won't tell you how to do it or what's specific in your context. And I just see from some of the questions that have been posed already, and a lot of them are around how long you should keep recordings or how long you should keep records or data or information. I have a different answer for every one of you. You know, it's not something that just has a generic answer. There are different requirements. So that's the first thing, is most people don't know what to do, so make sure that you get the right level of education that's specific to your business and specific to your workforce. The second point, and this is my favorite because POPIA has been in, it was in a bill format since 2009, like a concrete bill that we could actually, that was workable. And sometimes I will even still refer to it as the bill instead of the act. And then it was signed in 2013 and there were regulations in 2018, and it's taken a long time. But I think most organizations underestimate the amount of time that it will take to get ready. So if you look at what's happened globally and what's happened overseas, organizations in Europe have had 2 decades to get to grips with data protection, to get to grips with protecting personal information, handling it responsibly and ethically, and they're still getting it wrong. There are still international data breaches happening. There are still things after 20 years of focusing on this or doing things in the data protection space. So don't underestimate the amount of time that it will take to get ready. Larger organizations will need more time to get organized. How do you want to structure yourself? Who is the information officer? Who are the deputy information officers? How are you going to do this in your business that makes sense? Smaller organizations usually are a little bit more adaptable. So you can appoint one person to take the responsibility for this. And it usually, if they need to drive a change, it's easy to tweak a process here or there. But sometimes larger organizations have got these massively complex systems and processes that make it very difficult. And also, larger organizations are like the Titanic. They don't steer quickly. They aren't going to miss that iceberg. They aren't able to change or adapt as quickly as some of the smaller organizations. So that's the second point. Don't underestimate the amount of time that it's going to take you to get ready. And then the third point that I just want to talk about is there seems to be a lot of people that I talk to seem to think that they can get away with minimum compliance. But because we have to go down to such a detailed level on our data, if somebody can explain to me what minimum compliance is, I would welcome the conversation. It's one of those things that nobody can actually define, and we want to do the bare minimum that we can. If you take this from a different perspective, you shouldn't be doing this because it's a compliance requirement. We should have been doing this all along. And it's actually almost sad that we have to have laws in place like this to almost force organizations and companies to do the right thing when it comes to people and the use and protection of their data. What I'm starting to see in this place is that the information regulator notwithstanding, they will ultimately be responsible for regulating this across the country. But from at least the experiences that I've had, is that we're starting to see a much more self-regulating approach. And this is where it's really applicable to you. You, as employers, may have seen this in your tender departments or when you go out to tender. And so what I can just say on that is that companies are starting to take this seriously, and they are starting to ask other companies what they are doing with their data, how they are handling it, how they are protecting it. Do you comply with POPIA? who's your information officer? Do you have information security? What information security do you have? And I think that is one of the ways that this is going to become important or relevant in the South African market. So if you are going out to tender and asking third parties or other companies to do work for you that involves processing personal information, make sure that you're doing an appropriate due diligence on them up front in the space of data protection, information security, and privacy. And likewise, you're going to be getting these responses from your clients who are going to want to do business with you. And it might be that it might not be a competitive advantage per se, but it might be that make or break thing. Do we use you or do we use one of your competitors? Well, your competitor's better at privacy and data protection than you, so we're going to go with them rather. So make sure that you have your answers ready for those. Make sure that you are open and transparent with your clients. Talita spoke about openness. Transparency is one of the key principles of privacy and data protection, making sure that organizations or that people know what you're doing with data. And the challenge with that is if you lie or if you tell untruths, you will get caught out at some point, and then the consequences will just be worse for you. So those are my three, really. Make sure that you get education right within your organization. Don't underestimate the amount of time that it's going to take to get organized and to change your business. And also don't think about this as a minimum compliance thing. This is systemic, it's holistic, it involves practically every area of your business. So make sure that you're ready to respond to questions that other organizations might have on your data handling and protection practices.
Thank you very much, Russell. So that is sort of our high-level overview of POPIA. What we do want to do now is engage in some of the queries we've received and hopefully get to some of the interesting questions that have already been submitted. We see there's some overlap, so we hope to be able to address many of them. I think the first main question we often receive from clients is this issue of processing employee personal information. And do you need their consent to use and process their personal information? And do you need it on each occasion that you do it, or for every situation that you do it? What steps should employers take in this regard? Talita, what steps do you think employers should be taking in relation to their employees?
Yeah, look, the Act does give us guidance in the definition of consent. It says consent is any voluntary, specific and informed expression of will in terms of which permission is given for the processing of personal information. So you need to be able to meet those three criteria. It needs to be voluntary, specific and informed. Now, said, you know, in the employment context, there's many purposes that can be identified right up front when you are joining your employer, for which the employer can legitimately process this information. And I think that a consent in an employment contract to the processing of information for these explicit defined purposes, such as performance management, payment of remuneration, engaging with benefit providers in order to make sure that your pension and medical aid contributions are paid, those kinds of things, I think you can actually have that consent up front in an employment contract. Definitely also in an application form where the employer requires consent to do background checking, qualification checking. That consent that the employee is giving or the applicant is giving is specific, voluntary and informed. Now, there might be instances later on in the employment relationship where you may require additional consent from the employee in that very specific circumstances. And an example might relate to an employee's health information. So when you are considering processes in an incapacity process, for example, where an employee is too ill to work, and you would like the employee to submit to a medical examination and to take the information from the medical doctor into consideration, I think you would need additional consent that at the time is informed. I don't think that you would be able to rely on a consent upfront in the employment contract that whenever I agree to submit to a medical examination and to provide you with the doctor's notes and opinions. So I think it is fact specific. So it is important, I think, to have a consent form or a consent clause in your employment contract. But of course, consent can be withdrawn. And then in those circumstances, you need to assess whether there are any of the other grounds on which you could rely for the processing of that particular information. So as I said, consent is not the be-all and end-all, and there are other circumstances in which you can potentially process information, but it means that you just cannot just hide behind a consent. You need to think about what you are processing and the purpose for which you are processing the information.
Agreed, Talita. Yeah, I mean, as you said, consent can be withdrawn. That's a big concern. So to find another ground which you can rely on is first prize. So if an employee does withdraw their consent, you can say, well, we're doing it for purpose of to comply with your employment contract, in our legitimate interests, additional grounds. And in those cases, whilst you don't need the employee's consent, they need to, as Talita alluded to earlier, receive certain notification requirements. You need to inform them that, this is the information you collected, these are the purposes, whether you need their consent or not, those notification requirements need to be adhered to. I think moving to the storage of employees' personal information. This is a common question we get, and as Talita mentioned earlier, one of the conditions is requiring that you have the necessary security safeguards in place to secure personal information that you hold. And POPIA says you must put in place appropriate, reasonable, adequate, and technical safeguards. Russell, what does this mean? What measures should employers be looking to put into place? Can they store it on a shared Google Drive? Can they store it in clouds? What if the clouds are situated overseas? Can you provide some guidance for us?
Well, it's a very interesting and detailed question. But just to start with, you need to have some sort of appropriate measures. Now, the Act says that they can be technical or organizational. So organizational might mean that you have a specific process around this, and technical means that you're putting some sort of technology in place or something like that. So you might look at technical as being something like password protection or encryption, but your organizational layer around that might be educating employees or having a standard process. So when you are using this type of information, make sure that you password protect it before you send it via email. That's not a technical thing, although there are tools and they can be quite expensive that can do that for you automatically. But you can put these kind of controls in place that are not technical, they are organizational. And usually what I've seen, although I have seen some like really bad practices, but typically in organizations, your HR and your payroll departments usually get this right a lot quicker because of the nature of the information that they are processing. They have to process sick notes, they have to process people's salary information, and just by default there's this understanding within the HR communities or human capital communities that this information is to be protected. So that is one of the things that we'll need to look at, not just from an employer perspective, but across the organization, is this consideration of least access and making sure that the fewest number of people can get access to that data. Only those people who need to use it to execute on the purposes. So while sharing in, let's start with shared network drives, is perfectly fine, if those are open to your entire organization, then that's not okay. I wouldn't be comfortable if people saw what my salary information was if it was just stored on a shared drive. So making sure that you've got that. There are also some other guidelines that we can take from international regulators, and they look at the idea of, especially when it comes to things like sensitive personal information which could cause damage or distress to a person if it is compromised. And the Information Commissioner in the UK is saying that in those circumstances, that kind of information should be encrypted. It should be password protected in some ways. And there are relatively simple ways of doing this. You can create a secure zip file. There are free tools out there that allow you to password protect PDF documents. And so it is possible to do this, but it does mean a change in your organizational culture and in the processes that they go about on a day-to-day basis. The second part of your question is really, can we store this in the cloud? So now there's really two schools of thought. First of all, I know that every time I'm in a session with Microsoft, they tell us they are very proud to announce that they spend $1 billion a year on information security. $1 billion. That's more money than most companies' turnover. So let's just be real here. Would you rather put your information in with an organization that's trying its best to protect it, knowing that if they are compromised, that's their reputation shot? Or would you rather try and do it all yourself? Try and hire scarce skills to make sure that information security is embedded. The other school of thought is really the open source school of thought. So when it comes to cloud, some of the open source platforms like Drupal, there are people all over the world looking at this. So you've got millions of people looking at this, and so they're more likely to pick up any security holes that might be found in these systems. But it does come back to data protection, and you need to make sure that you do what's right for your organization, and that you can demonstrate that you have at least taken some steps, both technical and organizational, to make sure that information is stored and protected wherever it is. If you're following good data security practices, and I say data security very specifically, it doesn't matter where it is. If it's in the cloud, if it's on a flash drive, if it's on a laptop, if that is protected and nobody can get access to it and it gets compromised, it's fine, because no one has the password, nobody can get into it. Does that answer the question, Nadine? Is there anything else?
It does. No, thanks so much, Russell. A lot for employers to think about, specifically in safeguarding the information that they hold.
Oh, there's one other thing. Sorry. Like I said, I can talk about this for days. Recently, in a landmark case in the European Court of Justice, they have now held that the Privacy Shield agreements, which allowed transfer of data from Europe to the US, are no longer valid. So companies that are transferring information to the United States can no longer rely on those contracts and need to put in additional contracts like the standard contractual clauses, as well as do some form of due diligence on those companies. So the United States, interestingly enough, is technically not a safe space for personal information anymore.
Thanks so much, Russell. I actually see we had a specific question asking whether Singapore and Canada would be regarded as sufficient. And unfortunately, we don't know the answer off the bat. We would really need to go and consider their laws and see whether their laws provide the similar provisions that POPIA does. And then, of course, as I said, the cautious approach would be to still enter into a data transfer agreement with that third party in the country. The UK, interestingly, created a list of countries that would be regarded as providing sufficient protection. And we are maybe too hopeful, but we are hoping that the Information Regulator may in time actually provide a similar list of some of the countries that she regards as having adequate protection. But we don't, unfortunately, yet have that guidance.
And hopefully we'll be on the list of the UK.
Yes, hopefully we will be on the list of the UK. A number of GDPR specialists have actually found POPIA, if not the same law, actually more extensive than the GDPR. So we should definitely be regarded as providing adequate protection. But as Russell just mentioned, with the US data agreement just being set aside, we don't know. And it really may be a sort of case-by-case basis and to see how it is implemented. One of the questions which we just want to briefly touch base with that we often get from clients is relating to the sharing of personal information in light of proposed transactions, due diligence investigations, and even retrenchment exercises. Now, POPIA will obviously apply to all these processes. And in a due diligence investigation, when you are sharing information in a virtual data room or even hard copies of information, you want to bear in mind the principle of minimalism. You must only provide the information that is actually necessary and required for purposes of the due diligence or the proposed transaction. Now, generally, a seller can provide that information on the basis that it's in their legitimate interests and even in the purchaser's legitimate interests. However, when you get to issues around special personal information, we don't have that general ground of legitimate interest. And you may then, in circumstances, require employees' consent, or alternatively, which we often recommend, is to de-identify the information, as Talita mentioned earlier. POPIA won't apply to information that has been sufficiently de-identified to the extent it can't be re-identified. So that may be, a good way to sort of get around this issue of requiring employees' consent. We have seen it often in due diligences. You want to see health information relating to occupational injuries, or you want to know the trade union membership numbers in an organization. Here, we advise to try and redact the personal information as much as possible. So you're not providing employees' names with it, their details, and rather just statistics for purposes of them ascertaining the risk. Similarly, for a retrenchment exercise, a lot of our clients get requests for information from trade unions or affected employees for, example, the length of service of other employees where LIFO is being applied as a selection criteria, or details relating to employees' qualifications. Now, the Section 189 of the Labour Relations Act requires and puts an obligation on employers to provide sufficient information to affected employees and trade unions to allow them to meaningfully consult. Having said that, Section 16 of the Labour Relations Act also talks to the disclosure of information. And one of the reasons why an employer can refuse to disclose personal information is where it contains private personal information relating to an employee and their consent has not been obtained. So again here, it really is the principle of providing only what is necessary to require for meaningful consultation. Instead of providing a list of employees' names and their years of service, rather provide the employee codes, or something where you're limiting what you are providing and it's only for that legal purpose. Similar to a 197 transfer, 197 stipulates certain information by law that must be shared, your valuation of accrued leave, your accrued severance pay, anything in addition to what the LRA requires, once again, must be really strictly necessary, must be justified on your legitimate interest or the purchasers in taking over the employees. And if it is special information, we just caution that an employee's consent may be required if it's not sufficiently redacted. Talita, we've received an interesting question as well, and one that's not uncommon to us, relating to photographs. The question relates to, if you take a photograph at a rugby stadium with these people in it, do you need their consent now to upload the photograph? And as you said, we're sitting on this lovely webinar, our videos are playing, and Bowmans is going to post a copy on their website this afternoon. Are they allowed to do this?
I was hoping you are going to answer that.
Pick me, pick the non-lawyer.
I will give like a principle, and then please add to that. It's not just that, we might be sitting, we are now all sitting in South Africa, and our webinar is being recorded, but it's very possible that we may have a webinar with participants from Kenya and Uganda and the US and everywhere, and in all over the world, the webinar can be accessed. And, that is a recording and a video, and a photograph like a recording shows your race. So it may very well, and we take the view that it is special personal information. So it is probably only appropriate to post that recording with the consent of the participants. Now, by participating, we probably are giving our tacit consent to this webinar being recorded and being posted. And if we had any issue with that, we should have spoke about that. Now, the rugby stadium, I mean, you go to the stadium, you are having a good time, the cheetahs are winning. And there you are, you know, in all orange and on the front page of the newspaper. And no one would have asked you for your specific consent to the newspapers taking that picture and putting it on the front page of the newspaper. But by attending a public event like that, there is an argument that you probably to, you know, the press being, well, the press taking pictures of you and placing that in a newspaper. If you are at a work function and there's photos being taken and those photos are placed on the Facebook page or the website of the company, have you given consent? Well, it is probably good for the employer to have a notice up saying, we are taking pictures, this can be placed on our social media platforms. If you have a problem with that, please let us know. And then if you do let them know, then the employer must be careful not to put your picture if a picture was taken of you. If it is posing for the camera, you probably gave consent. I mean, you're not going to then say, but actually, you know, I never consented. You posed for the picture. But please, and
of course, I mean, if you take a photo of me at my end of year function, and I smiled at the time, but I think it's an awful photo that Bowmans now published on their website, I can surely ask for them to take it down, which I do advise employers at that time to do, as I'm objecting to them processing my information. But it really is case-by-case basis. If you're taking a picture of a crowd, you may not be able to identify their faces, in which case, you know, the POPIA won't apply. So it really, but it is, as Talita mentioned, being regarded as special personal information. The regulator herself in actual seminars has said that they regard it as special personal information. So additional protections will need to apply. I see we are running short of time, so there is one topic I want to get onto with Russell, but there was just a few questions specifically a lot relating to this information officer, and I thought I'd quickly try and address some of them. The one is it only large companies that are required to appoint information officers? No. The appointment of an information officer is to any responsible party that's processing personal information, regardless of the size. Another question is, if we have an information officer in a group company overseas, can it also be the information officer for purposes of POPIA? We have taken the view that you can. POPIA doesn't require the individual to be situated in South Africa. So you can still make use of an information officer in Europe and register them for purposes of POPIA here if they can obviously oversee the implementation of POPIA and perform those duties. The guidelines, we don't know when they're going to be finalized, but hopefully it will provide further information and we will sort of keep an eye out on that. And the duties and steps you need to take are, you know, set out specifically more in the regulation. So that would be a good starting point. And we, of course, then here to assist. Russell, talking about going back to Experian and data breaches. We understand from the information regulator this morning that between May this year and August, 25 data breaches have been reported. What should employers do if there is a data breach, and what sort of practical steps can they take?
So before we even start on this topic, I'd just like to say it's not a case of if, it's when. I know a number of organizations have said, we will not tolerate data breaches, we will not we will not have this happen to us, but it can happen to you. It's happened to Uber, it's happened to Google, it's happened to large organizations that put a lot more focus and time and attention into this. If you are processing personal information and that information can be used by fraudsters to do something that will make money for them, you can be guaranteed that they're going to target you at some point in the future. Not only that, but you have to deal with all of your, as I mentioned at the beginning, employees who don't really know what they're doing and who can make mistakes at any point in any time. So it's not a case of if, it's when. And what I would advise is that you are prepared, that you have some sort of standardized process in place and be ready to notify people, be ready to notify the regulator to just give them a heads up and say, listen, we've got something going on, we're not sure what it is, but we want to tell you about it. once we know what it is, then we can go ahead and notify people, because sometimes you might know that you've been breached, but you don't know who's been affected. The other thing is that you must try and tell people that have been affected as quickly as possible so that they can take appropriate safeguards themselves and try and prevent their bank accounts from being cleared out, or fraudulent furniture accounts from being opened up, or those kinds of things. So it's no good to just leave it. And we are working towards this at Alexander Forbes and making sure that we are responsible and can handle these. And sometimes it could be something as small as one person inadvertently sends an email out to another person, to the wrong person, to a different Russell, for instance. Or it could be in the case of an Experian where 24 million people plus 800,000 organizations are compromised. And that really has set the benchmark high for the most massive data breach that South Africa has seen and probably will see. Experian has information that most other organizations give them. So make sure that you're prepared, have a process in place, and be ready to notify people. Also look at timing. There are cases where you might notify too early, in which case you might create a lot of panic in the market unnecessarily, or in the case with Experian and what they're coming under fire for is notifying too late. And I understand that there was a legal process that they had to go through in order to attach that information. But the fact of the matter is that information has been out in play for 3 months. That you can have copies and backups of your backups on cloud servers all over the world, especially if you're a fraudster. And there's no traceability of that. So once a breach has happened, the data is compromised, and you must be prepared to notify sooner rather than later.
Thank you so much, Russell. And I see everyone, we've just actually run over our time, our apologies, but thank you very much for joining us. Thank you, Talita, and thank you again, Russell, for participating. We hope that this provided some value, and please don't hesitate to reach out to us with any further questions that you have, or should you require any further assistance in ensuring compliance with POPIA by 1st of July next year. Thank you very much, everyone.
Thank you.
Just do.